Today in this lecture we will continue to see the constructive trust. We have already seen in our previous lectures section 83 and section 84 of the Trusts Ordinance. In terms of section 83 of the Trusts Ordinance, where the owner of the property transfers such property and from the attendant circumstances, it cannot be inferred that he intended to dispose the beneficial interest therein, then the transferee must hold the property for the benefit of owner or his legal representative. What we have seen in section 84 of the Trust Ordinance, where the property is transferred to one person for the consideration paid or provided by another person, and it appears that such person did not intend to pay or provide such a consideration for the benefit of transferee, then the transferee must hold the property for the benefit of the person paying or providing consideration. These are the two sections that we have seen in detail. Now, according to this one, today what we are going to study the presumption of advancement. Where an owner transfers the property to B, such owner did not dispose the beneficial interest therein, then the transferee must hold the property for the benefit of transferor. That is the section 83. Or A provides the consideration, but the conveyance made to B upon the proof of such facts, the presumption of trust arises. The burden is on the B to rebut it. As we have seen, you will study in your final year law of evidence. There is a separate topic that is known as burden of proof. Now here what we are seeing, as per section 83 and 84, one person in 83, such person must be the owner of the property. Then the owner transfers the property to B. At the same time, such owner did not dispose of the beneficial interest. Then there are two matters or two issues must be proved by the owner of the property. First thing is, owner must prove that he has transferred his property to B. Second thing, he must prove that he did not dispose the beneficial interest to the transferee. Likewise, in section 84, A provides consideration, then A must prove that he has paid the consideration. But the conveyance made to B, then he must prove that he has paid such consideration not for the benefit of B. Then there are two matters in each section, two issues must be proved or established. Once again, I would like to tell you this one. And in terms of section 83, owner must prove that he has transferred his property to another person transferee. At the same time, he did not intend to dispose of the beneficial interest therein. and two issues must be proved. In terms of section 84, A must prove that he has provided or he has paid consideration. At the same time, he has paid such consideration not for the benefit of transferee, because he has paid consideration and he asked the owner of the property to transfer to B. First place, he has provided or he has paid such consideration to the owner. At the same time, A asked such owner to transfer the property in the name of B. Then first place, A should prove that he has paid or provided such consideration. The second issue that he should establish is that he has paid such consideration not for the benefit of transferee. He has paid such consideration not for the benefit of transferee. Upon the proof of those issues or facts, the presumption of trust arises. And the burden is on the B to rebut it or disprove it. But A is in loco parentis to B. Then what the situation? Now we have seen in two cases or in two sections, 83 and 84. What we have seen, owners transfer the property to B. And second one, in terms of section 83, we have seen A provided the consideration and conveyance made to B. But in those circumstances, say suppose if the relationship between those two parties within loco parentis, then what's the situation? Then the counter presumption arises that purchase was for the B's benefit and burden is on A to rebut it. Now we will see in this slide here, section 83, as we have seen, A transfer the property to B, but A did not intend to dispose of the benefit therein. Then in the same case, without say A and B, husband transfers his property to wife. But he can't say he transferred his property to wife not for the benefit of wife, because there is a general presumption if the parties are in loco parentis relationship, then if the husband transfers his property to wife, it is for the benefit of wife. It is for the benefit of wife. That's why it is known as presumption of advancement. That means the property transferred to wife by husband for the advancement of wife. The same concept we can extend to section 84 of the Trust Ordinance. Here again, A transfer the property to B, but C paid consideration to A, but not for the benefit of not for the benefit of B. In those circumstances, if you say that A transfer the property to wife, but husband paid or provided such consideration to A, in those circumstances, there is a presumption that it is for the benefit of wife. That's why it is known as presumption of advancement. If it is within the loco parentis relationship, then there is a presumption of advancement. then what we should do is, as we have seen in the previous slide, actually the wife should prove or rebut it, because it is for the wife. Then the rebut part vested to another person, as we have seen in the previous slide. As we have seen in the general concept, A provides the consideration, then the conveyance made to B. Then there is a presumption. After establishing all these things, the presumption of trust arises. But here, presumption of advancement arises. The second, if the parties are in loco-parentage relationship, then the presumption of advancement arises. Then we will move to other slide here. A must prove under section 84, the first thing, as I explained earlier, he has paid the consideration, and he did not do so for B's benefit. Otherwise, no presumption of trust arises. Once proved that he has paid, and he has paid not for the benefit of B, then there is a presumption of trust. Otherwise, there is no presumption of trust arises. Likewise, if you take the example 83, in considering, when you see the section 83, A transferred the property to B, but he did not dispose the beneficial interest. Once the owner of the property proved that he has transferred the property to B, but he did not transfer the beneficial interest to B. In those two things once proved, then there is a presumption of trust arises. Otherwise, there is no such presumption of trust. Then in considering whether the beneficial interest has been transferred under section 83, and whether the consideration provided for the benefit of transferee under section 84, relationship between the parties would be very relevant factor. Now, up to now, we don't see anything about relationship. We say that owner of the property transfers, A paid consideration, such thing. Now we say that husband transfer the property to wife, then what's the situation? Then there is a presumption of advancement. Likewise, if the husband paid or provided consideration for the purpose of purchasing another land or whatever in the wife's name, it is for the advancement of wife. Now we will see two decided cases here, Fernando versus Fernando. A man bought a sweepstake ticket in the name of his son. He was at the age of 16 years. When he won the first prize, the court thought that father, he is a poor fellow, and also he had no intention making a gift of this nature. Therefore, the presumption of advancement was rebut in this situation. Likewise, Pereira versus Solistica, in this case, this is a case under section 84. Gratian J thought that the presumption would be given effect under section 83. Two brothers held to be loco parentis has deposited money in the saving bank in the name of their sister, often sister because father and mother were dead. The court inferred from the fact they had retained the saving book that the beneficial interest under section 83 had not been transferred unconditionally and was subject to condition that their sister should marry according to their wishes. But really speaking, she married according her wish. Therefore, where the girl married a person in a different caste, she was held to be forfeited her rights in the money. Even though the brothers and sisters in loco parentis relationship, even though there is a presumption of advancement arises, but it can be rebutted. Now we will see resulting trusts. What is a resulting trust? First, a resulting trust is one which implied in favor of settlor or his legal representatives. It may be defined as the one where the property is incompletely conveyed. Property is incompletely conveyed, or where on the conveyance the beneficial interest in the property is incompletely disposed of and the property or indisposed beneficial interest reverts back to the settlor. Reverts back to the settlor. That is known as resulting trust. But under English law, it is known as two separate topics. Now the first one, constructive trust and resulting trust. There are two separate things in the English law. But in Sri Lanka, constructive trust includes resulting trust. When you see this one, the resulting trust is one which implied in favor of settlor or his representative. It may be defined as one where the property is incompletely conveyed, or where on the conveyance the beneficial interest in the property is incompletely disposed of. Then the balance property is there. The first place, incompletely conveyed. Second place, complete everything done perfectly, but there is a balance property. Then property or the indisposed beneficial interest reverts back to the settlor. Now we will see section 85 of the Trusts Ordinance. The trust is incapable of being executed. We have already seen this one, some extent we have seen in the unlawful trust, but here we will see as a resulting trust. Where a trust is incapable of being executed, or where the trust is completely executed without exhausting the trust property. The trustee, in the absence of any directions to the contrary, must hold the trust property or so much thereof as is unexhausted for the benefit of author of the trust or his legal representative. Incapable of being executed. Now the trust is created. It may be under chapter 2. Trust is created because of certain matter, certain issues. Incapable of being executed. It is incapable of being executed. Suppose the trust is created to give free books to the school children. After the trust is executed, the government decided to give free books to the school children. Then the trust is incapable of being executed because no point of giving books to the students because the government itself started giving free books. That one thing, incapable of being executed. Second thing is trust is completely executed without exhausting the trust property. Suppose now there's a trust to give some sort of beneficial interest to the law student for the 3 years period. Then the amount decided every month, say suppose 15,000 rupees should be given. But sometimes there's a fixed deposit, and from the fixed deposit they will get around 15,000 rupees per month. Then every month the 15,000 rupees given to the student. At the end of 3 years period or 4 years period, he becomes a attorney at law. But according to this deed of trust, the beneficial interest may be given until he completes his education. Therefore, once he has completed his education and say suppose he took oaths, everything is over. Then the beneficial interest must be stopped. At that time, when you see that even though the trust is completely executed, there's a balance money in the hands of trustee. In these two circumstances, trustee, in the absence of a direction to the contrary, then we must see the deed of trust. Whether there may be terms and conditions. In that terms and condition, if there's a directions given, then we must follow the direction. But if there is no directions given in the deed of trust, that's why here we say that in the section the law provides that in the absence of directions to the contrary, must hold the trust property or so much of as is unexhausted for the benefit of author of the trust. Then what we should do is, now there's a balance property, say in the example for the trust for the benefit of law student. At the end of 3 years or upon the completion of his attorney at law qualification, once he take oaths, everything is over. But still he has the property. Trustee has some sort of, say suppose 10,000 or 20,000 rupees money in his hand. Then he can't take that money. He can't take that. That is in violation of principles of law of trust, and also that is one of the violation of trust that we have seen in the trustee's part. Now here, then what he should do is, the trustee must hold the property or the whole such money that was unexhausted for what? For the purpose of, for the benefit of author of the trust. That means already the trust created by author of the trust for the benefit of another person. Now suppose executed, everything is done perfectly, but there is a balance money. In that money must be held for the benefit of author of the trust. That's why it reverts back to the author of the trust. That's why it is known as resulting trust. Illustration given in this one. Yes. Illustration given. First illustration. A conveyed certain land to B upon the trust and no trust is declared. He has transferred the property to B saying that this is for trust, but no deed of trust declared. Then that is known as we have seen in the first one. Now the property with the transferee. Property with the transferee. Therefore, the trust is incapable of being executed. Because property transferred, but there is no deed of trust. That was the second thing. Upon the trust to be thereafter declared, but no such declaration is ever made. It was said that there will be a declaration of trust, but no such declaration is ever made. Then that also again incapable of being executed. Upon the trust that are too vague to be executed, then incapable. Upon the trust that become incapable of taking effect. Suppose the government or the parliament enacts a law which prohibits the actions or the aim of the deed of trust. Then upon the trust is executed perfectly, but incapable of taking effect, in the sense there may be a law passed after such execution of trust to prohibit certain acts for which it is executed. Then the fifth one, the trust foreseen, but C renounces his interest under such. Now, as we have seen in the example that just now we have seen, the trust is created for the benefit of law student at the law college, but the law student refused or renounces his interest. Then you can't proceed. Then all these circumstances, the transferee here in this illustration B must hold the land for the benefit of A. Then we will see illustration B. A transfers 10,000 rupees in 4 persons to B in trust to pay interest annually accruing due to C for her life. A dies, then C dies. B holds the property or the fund for the benefit of A's legal representative. A conveys the land to B upon the trust to sell it and apply one portion of the proceeds for certain charitable purposes and other portion for the maintenance of particular form of worship. B sells the land, but charitable purpose wholly fail. And the maintenance of worship does not exhaust second portion of the proceeds. B holds the first portion, it was given for the charitable purpose, and second portion unapplied. Because we say that maintenance of worship does not exhaust the full amount, then there's a balance money. Then those things, the first portion should be the in whole amount, the second portion, whatever unexhausted portion, should be held for the benefit of A or his legal representative. Then we will see the D illustration. A bequeaths rupees 10,000 to B to be laid out in buying a land to be conveyed for the purposes which either wholly or partly fail to take effect. B holds the benefit of A's legal representative, the indisposed of interest in the money or land if purchased. That's clear. Then according to section 85 of the Trusts Ordinance, a resulting trust arises in two situations, namely where a trust is incapable of being executed. Second situation, where the trust is completely executed but without exhausting the trust property. But resulting trust can arise as only in the absence of a direction to the contrary contained in the terms of trust. Suppose if the terms and conditions of the trust provide that it should be given to somebody, the balance property, then there is no resulting trust. In the absence of directions to the contrary contained in the terms of trust, then only resulting trust arises. The constructive trust, thus a relationship with respect to the property subjecting the person by whom the title of property is held by an equitable duty to convey to another person on the ground that his acquisition or retention of the property is wrongful, and also he would be unjustly enriched if he were permitted to retain such property. As we have seen in the concept of law of trust, the basic concept, underlying concept in the law of trust, the trustee should not be enriched in any circumstances. Then we will move to section 86 of the Trusts Ordinance. This one we have seen when we study the unlawful purpose of the trust. We have seen that. Therefore, I don't want to take much more time on these 86 and 87. Already we have seen in detail. Therefore, just we will read and understand. The owner of the property transfers it for another for illegal purpose, and such purpose is not carried out into execution, or the transferor is not as guilty as transferee, or the effect of permitting the transferee to retain the property might be to defeat the provisions of any law, then the transferee must hold the property for the benefit of transferor. That we have seen very clearly in the lawful purpose. Then I'll move to next one, 86, section 87 of the Trusts Ordinance. That also we have already seen in detail under lawful purpose. Now we will once again try to see this, understand a section where a testator bequeaths certain property upon trust. The purpose of the trust appears on the face of will to be unlawful, or during the testator's lifetime, the legatee agrees with him to apply the property for an unlawful purpose, then the legatee must hold the property for the benefit of testator's legal representative. Where the property bequeathed and the revocation of bequest is prevented by duress, then the legatee must hold the property for the benefit of testator's legal representative. This section we have already seen, that's why I'm leaving. Where the property is transferred in pursuance of contract, this is section 88. Where a property is transferred in pursuance of a contract which is liable to rescission or induced by fraud or mistake, then the transferee must, on the receiving a notice of that effect, hold the property for the benefit of transferor, subject to repayment by letter of the consideration actually paid and subject to any compensation or other relief to which the transferee may be by law entitled. That's clear. There's a contract entered into, but the contract entered into by fraud or mistake or whatever, then the transferee must hold such property for the benefit of transferor. Now, even though under the law of contract, suppose there are two parties and entered into a contract, fine. But if there's a mistake or fraud, we know how to deal with that contract in terms of law of contract. But you can bring those situations under law of trust also. Then if you bring and if you prove those things before the court of law, then the court will declare that the transferee holds such property on trust. Then the next one, section 89 of the Trust Ordinance. Where a debtor becomes the executor or other legal representative of his creditor, he must hold the debts. Generally, up to now, we have seen property. Now, he must hold such debts for the benefit of person interested therein. Now, section 90. Once I can remember, this section was examined in the intermediate examination. Now we will see where a trustee, executor, partner, agent, director of company, legal advisor, any other person bound in fiduciary character to protect the interest of another person by availing himself of his character as trustee or executor or partner, agent, director of company, legal advisor, any other person bound in a fiduciary character, use such character, gain something for himself, suppose any pecuniary or monetary advantage, or where any person so bound to enters into any dealings under circumstances in which his own interests are or may be adverse to those of such other person, thereby gains some sort of benefit for himself, then all these situations he must hold the benefit for such other person under section 90 of the 90 of the Trust Ordinance. Then as a trustee, say as we are law students, as a legal advisor officer, you may come to know certain secrets of the institution where you are employed. By giving information to some other competitor, if you get some sort of or gain some sort of money, in addition to all these actions, even the institution asks the court to declare whatever you have gained out of such transaction the institution asks the court to declare trust on the property or on the money, whatever you have gained out of using this character and using this character. Now we will take an example like this way. There's a communication center or communication institution. Then all the time they find some more attractive package, and just they publish those package to the people and attract the people to their communication institution. Then at that time, as a legal officer, finally must see this is all right, this is in accordance with the law of Sri Lanka, then finally they will publish. But when you see as a legal officer of these packages, if you give information to the competitor that we are going to introduce this company, going to introduce a package like this, before that the other company can release such package and attract so many people to their communication center or institution, for which they would have paid some money to you. Then you must hold such money for the benefit of this institution where you employed. Once again, where a trustee or executor, partner, agent, director of company, legal advisor, and other person bound in a fiduciary character to protect the interest of another person. All these people, trustee, executor, partner, agent, director, legal advisor, all these people, what they are doing, they are protecting the interest of companies, partners, agency, principal, company, all these things. But at the same time, by using as a director of the company, as a partner of this partnership, as a legal officer in the organization, using that character, using the office of that, gains some sort of benefit for yourself, then you must hold such benefit for the benefit of company. Now here the illustration given, an executor buys at an undervalue from B, a legatee, his claim under will. B is ignorant of value of the bequest. A must hold the benefit of B, the difference price between the price and the value. Likewise, second one, it's more clear. A trustee retires from his trust in consideration of his successor paying him some sort of money. Now there's a trust, there's a board of trustees, there are members in the board of trustees. One member retiring or resigning from this trust. Then you pay money to that retiring trustee and join that trust as a trustee, then you must hold such money for the benefit of beneficiary of such trust. Then we see the third one, see illustration C. A partner buys land in his own name with a fund belonging to the partnership. A holds such land for the benefit of partnership. Then we will see D. A partner employed on behalf of himself and his co-partners in negotiating terms of lease fraudulently stipulates with the lessee for a payment to himself of 1 lakh rupees. Then A must hold such amount of money for the benefit of partnership because he has been nominated to negotiate the terms and conditions of the lease. He stipulates with the lessee for a payment for himself of certain amount of money. And he settled the terms and conditions perfectly because he has been paid some sort of money by other person. Then now that person, the partner must hold such property or whatever money he received from other person for the benefit of partnership. Illustration E. A and B are partners. A dies and B, instead of winding up the affairs of the partnership, retains all the assets in the business. B must account to A's legal representative for the profit arising from A's share of the capital. That's simple. Now we will see another two illustration. A, an agent employed to obtain a lease for B, obtain lease for himself. A holds such lease for the benefit of B. No difficulties there. Then I will move on G, illustration G. Illustration G. A guardian buys up for himself encumbrance on his ward B's estate at an undervalue. A holds for the benefit of B such encumbrance, so bought, and can only charge him with what he has actually paid. Once again, A guardian buys up for himself encumbrances on his ward B's estate as undervalue, and A holds such benefit of B, the encumbrances whatever he bought, and can only charge him with what he has actually paid. Now the words of section 90 of the Trusts Ordinance have the effect of constituting an executor, partner, agent, director of company, legal officer or legal representative, or trustee in all circumstances where such person gains a monetary advantage, pecuniary advantage, by availing himself of his character or by entering into dealings where his interests are adverse to that of person whom he is bound to protect. Under section 90, agent or any other fiduciary would be trustee of secret commission. This is like secret commission, or in other words you can say bribery also. But here we will simply say secret commission by using the office of trustee, executor, partner, agent, director, legal representative. He got some sort of secret commission, but he must hold such commission, secret commission, for the benefit of company. In England, a person with a beneficial interest in property which is in the hands of fiduciary can follow the property until he reaches the hands of bona fide purchaser without notice, or until it has ceased to be identifiable. This principle has incorporated, we have already studied, into our law of Sri Lanka, or in our law Trust Ordinance by section 65 to 69 of the Trust Ordinance, but it is available only against a trustee from transferee from the trustee. In the balance sections we must see 91 to 98. You can read and understand. I don't want to waste time on those sections, just you must read and understand. Now we will see the differences. Now trustees of the trust arising under chapter 9 of the Trust Ordinance on the same footing as trustees of trust created under chapter 2 of the Trusts Ordinance. Now we are seeing two different trustees, constructive trustees, express trustees. Now we will see here. Generally, both are trustees, right? Now section 94 of the Trust Ordinance places trustees of the trust arising under chapter 2, subject to two exceptions stated in section 97. Now we are differentiating the trustees, constructive trustees from express trustees. First one, where he rightfully cultivates the property or employs in trade or business, he is entitled to the reasonable remuneration for his trouble, skill, loss of time in such cultivation or employment. Now the constructive trustee and the express trustee. Now in the constructive trustee, if the constructive trustee cultivates the property or employs such property in trade or business, he is entitled to the remuneration. Then second one, where he holds the property by virtue of contract with a person for whose benefit he holds it, or with anyone through whom such person claims, he may, without permission of the court, buy or become lessee or mortgagee of the property or part thereof. Now under express trust, the trustee should not be entitled to get any sort of remuneration. But the constructive trustee is entitled to the remuneration. But there, in the express trust, the trustee is not prohibited to get any sort of remuneration, but as an entitlement, he can't claim anything. But under constructive trust, he has the entitlement for remuneration. Section 52, which applies to the trust created under chapter 2, states that trustee may not charge for his services except where there is an order of the court. Then charge for service in the sense it may be remuneration. Except on the order of the court, he can't get anything at all under Chapter 2. Trustees under Chapter 2. But under Chapter 9, the trustee is entitled for remuneration. While Section 52 leaves the award of the remuneration to the discretion of the court, but 97B gives a trustee a right to it. Phillips versus Boardman, the court in granting limited remuneration to a constructive trustee stressed that he had acted bona fide. But it may be argued that effect to rightfully is that he must employ the trust property in circumstances in which, as a trustee, it is proper for him to do so. The person who accepts the confidence is called trustee, as we have seen in the interpretation section, that is section 3 of the Trust Ordinance. The person holding a property in accordance with any of the preceding sections of this chapter, in terms of section 97, this chapter, that's the chapter 9, must, so far as may be, perform the same duties and save as in this ordinance otherwise provided, is subject, so as may be, to same liabilities and disabilities as if he were trustee of the property for the person whose benefit he holds it. Then, other than the exception given in section 97 of the Trust Ordinance, more or less all the liabilities and disabilities more or less same as express trustee, the constructive trustee. Now what we have seen here in terms of section 97 of the Trust Ordinance, except in the two cases, remuneration and buying a property, except those two cases, all other cases, the rights and liabilities and disabilities of the express trustee are more or less same as constructive trustee. Therefore, combined effect of sections 3 and 97 of the Trust Ordinance is that trustee includes a constructive trustee. That we have seen this section 98, that's the last section in constructive trust under chapter 9. Nothing contained in this chapter 9 or this chapter, now we make it as for understanding purpose, nothing contained in chapter 9 shall impair the rights of the transferee in good faith for valuable consideration. Now we say in 83, A transfer the property to B. In 84 we have seen A paid the consideration but not for the benefit of B. The conveyance made on B's name, those things we have seen. Whatever it is, if it is done in good faith for valuable consideration, then the rights of the transferee should prevail. Creation and obligation in evasion of any law for the time being in force, we have studied in lawful purpose, then I don't want to waste time on that. We will move to second part of this slide. First part of this section is a reminder that section 69 to 72 apply to chapter 9. Those are wrongful employment by a partner trustee of trust property for partnership purpose, liability of beneficiary joining in breach of trust, rights and liabilities of the beneficiaries transferee. In second part, the word evasion that we have clearly studied in our unlawful or lawful purpose, but just we'll see here. Second part, word evasion implies an intentional attempt to circumvent the existing law and does not touch a case which merely happens to conflict with the strict law that we have seen very clearly. Therefore, section 98 does not require trust of a land arising under chapter 9 to be notarially executed. Finally, that we have completed constructive trusts under chapter 9 of the Trusts Ordinance. Now we have studied section 82 to 98. More or less we can say section 82 must be the introduction to the chapter 9. Then from 83 to 91 we have seen very important section, especially in 83 and 84, 85, those three sections are very, very important. And finally, we have seen section 98 also. Now, that is the end of constructive trusts. Thank you.